Good afternoon. This is a webinar organised by the Bingham Centre for the Rule of Law on the report of the second module of the Covid-19 inquiry on core decision-making and political governance. I'm David Feldman, and I'm going to be chairing the session. We have a terrific panel of speakers. I'll introduce them as they come on to speak, but let me just say now we have Dr. Ruth Hussey, Professor Jeff King, Dr. Rebecca McKee, Dr. Colin Cachey, and we shall be speaking in that order, I think. The reason for having this inquiry under the aegis of the Bingham Centre is that the Bingham Centre coordinated a report which was published earlier this year on the legislative and governmental aspects of the rules relating to COVID. It was the Independent Commission on UK Public Health Emergency Powers, and that was chaired by Sir Jack Beatson. Sir Jack isn't available to join us this morning, which is why I'm standing in for him. We'll speak for 15 minutes each, and I shall introduce each speaker as they begin. First of all, Dr. Ruth Hussey. Dr. Hussey was a member of the Independent Commission I mentioned just now. She retired as Chief Medical Officer for Wales in 2016. Born and brought up in North Wales, her career developed in England, initially training as a GP and working in academia, then as Director of Public Health in Liverpool, and then in strategic leadership posts in Northwest England for the NHS and the Department of Health. She was part of the Public Health Transition Team in the Department of Health in Whitehall before joining the Welsh Government. Ruth is Deputy Chair of the Health Foundation, Non-Executive Director with the Cheshire and Merseyside NHS Integrated Care Board, and a Trustee of the Reader Charity. In her not very copious spare time, she also chairs the NIHR School for Public Health Research Advisory Board and the Care Inspectorate Wales Advisory Board, and contributes to other research and policy groups. And from 2022 to 24, she was a member of the Commission, the Independent Commission. So over to you, Ruth.
Thank you very much, David. I wanted to kick off the proceedings with just some comments from a public health perspective, even though the Commission was very much about the use of law. And just to also, I guess, declare sort of an interest, because the Module 2 does set out the events in that initial response. And I did have some involvement in that period, even though I was no longer Chief Medical Officer at that time. I was asked to work with senior police colleagues to look at the preparedness of the local resilience teams during March 2020. And then I was asked to be a liaison officer between the Ministry for Housing, Communities and Local Government and the Greater Manchester Combined Authority during April and May in that initial response. So reading the report was interesting because I did have some direct experience at that time. And as you said, I also had regional responsibility in England, and I was around when the swine flu pandemic happened as well. So just sort of some context. And I think what's really important is that, and we need to keep it central at all times, is that the imperative in a pandemic is to take action to control the spread of disease and to deliver the best effective outcomes we can. And it was really positive and important that when we did the work on the Commission, that was absolutely foremost in our thinking, that we understood that was the point and the key purpose. And it was, again, really encouraging that the Module 2 report confirms that the central requirement of political administrations, and I'll quote, governments must act swiftly and decisively to stand any chance of stopping the spread of a virus. And again, that really emphasises the importance of why action has to be taken. And they also quote a lecturer in public law, Strathclyde, which again I wanted to quote because it also those comments bring out the dilemma that I think we face and the Commission wrestled with. So a pandemic requires an effective, fast and flexible response that keeps pace with the ever-evolving nature of the virus. However, there remains a fundamental tension. Emergency powers must balance the need for rapid action with robust parliamentary scrutiny to ensure that responses remain evidence-based, consultative and protective of human rights. And I think that tension, I think we exercised our thoughts around that challenge. It was at the heart of what we debated throughout our work, and the inquiry, I think, likewise had those issues to balance. So I was only going to comment on a few parts of the report and reference our work. I'm sure others may pick up similar points or want to explore other aspects of the legal framework. So the first point I was going to pick up on was the recommendation 16, which was the review of the applicability of the Civil Contingencies Act for future civil emergencies. And the recommendation was so that we're clear, is that Civil Contingencies Act is reviewed in order to use it as a first line response as an interim emergency framework until more specific legislation with appropriate safeguards is passed. And there are three elements to what's being considered: how it would be used in an public health emergency, what changes to the triple lock test would be required, and then guidance on when it would be used. And I think this is one of the first things that we considered as the Commission, and we did gather a range of views about the choices between the Civil Contingencies Act and public health legislation. And I think any review that comes on this particular recommendation, there is a lot of evidence in our report which will be very relevant to it. And one of the triple lock safeguards is necessity. And it's explained as it must be necessary to introduce emergency measures to prevent, control or mitigate the impact of an emergency. And it's only met if existing legislation is inadequate, either due to delay or inefficacy. And we actually went down the road of pursuing the notion of improving public health legislation so that the necessity test wouldn't be needed. It wasn't necessary to use the CCA. And so an area for exploration, I'm sure colleagues will pick up on that. Just a couple of thoughts. If the CCA, as is being reviewed, it's recommended it would be used as a first line defence or first line response. And just reflecting back on both COVID-19, but also swine flu, it typically emerges as a rising tide. And I guess in that review of using the CCA, it may be a situation, I think it happened with swine flu, if I remember rightly, that cases emerged in Scotland first. So one could imagine or envisage that in that sort of rising tide situation, the public health laws may already being used in devolved administrations. So I think the review needs to look at the balance between frontline response through or first line response through a CCA, which will be UK wide, and the balance of where that disease emerges and whether that would be actually problematic for applying a UK wide approach. And I'll come back to the timeliness of it. And the inquiry sets out clearly that there was an assumption made in February 2020 that the legislation might not be required until the end of March, and that the incident wasn't about to happen, that there was time. And of course, that is, we now know with hindsight, it was already emerging quickly. And so there was speed in trying to develop that legislation in mid-March. So I think there's two issues to think about in reviewing the CCA and its usefulness. One is recognising that the rising tide is happening. It's not easy. It may be in different parts of the UK. And that's something that would need to be factored in as to which legislation you might want to use. But probably more difficult is deciding when to take action. The inquiry talks about the importance of acting swiftly. And I think that's a key area to explore, particularly if one was leaning towards using the Civil Contingencies Act, because it has such powerful implications and it is UK-wide powers. A question I had was whether this would actually hold back or create hesitation in intervening. I think there's quite a few issues to explore in that review if that's pursued. You will see in our report that we went down a different route and proposed revising the public health legislation and made several recommendations. I suspect other colleagues will pick up some of those points. But in general terms, I think we felt more of the legislative basis that is available could be developed in advance. And it's really encouraging to see learning points from the inquiry, which if you look at the 10 points that are made, they're really recognisable as a good public health approach, with an emphasis on pre-planning the interventions and the legislative requirements that would be needed to enact them. And so there are 10 points made. In the interest of time, I won't go through all of them, but the first 2 points that are made are anticipate multiple scenarios and anticipate interventions and their impact on health inequalities. And I think addressing those two would guide better preparedness. We now know what the menu of interventions are, that they're going to be pre-described mostly. And we can also work in advance to understand what sorts of impacts should be considered in impact assessments. And then also what sort of legislation would be required to enact them. And this is something respondents told us during the commission, that we can do quite a bit of this pre-planning. Obviously, what we can't factor in with any certainty is what the public health threat might be, but we can be clear on the steps that are possible and engage politicians and, importantly, the public in their understanding, so that when we go into the next pandemic, we have well-rehearsed actions and a legal framework that enables us to quickly enact those choices. So that's what I was going to say about the legislation. I'm conscious of time, so I'm going to move on quickly. Intergovernmental working was highlighted in the report. And obviously the four nations have devolved responsibility for health. And so it was really welcome to see the recommendations 18 and 19, which reference the need to enhance that collaboration. And it could be that further development of the public health legislation, which is different in the four devolved administrations, could actually support more of that executive collaboration. One point we did make was the possibility of interparliamentary dialogue to support decision making. And I think that's something that would be really worth exploring to support the executive and enable a shared UK understanding of the issues. There's a small point I wanted to pick up, which is a separate one, but to do with national to local working. As England moves towards more devolution, I think the report notes that mayors find it difficult to contribute to decision making, even though they have some responsibility for health and the economy. So I think in thinking through the collaboration across the devolved administrations, I think, and this postdated our work, but the white paper on devolution in the English regions would be something to consider in future as well, so that because as I understand it, the new strategic authorities will have responsibilities in relation to health improvement and health inequalities, as well as economy and public services. So something else to think about in terms of the collaborative political decision-making environment. Finally, a couple more points. It was really important and reassuring to read that the Chief Medical Officer collaborated effectively, giving joint advice where was needed. And that's my experience when I was in the role, that it's a very strong collaborative approach. Our report went a bit further and recommended that the advice that Chief Medical Officers give should be available to the legislature. And I think that's really important to ensure informed decision making and aid transparency, especially as a time of potential for substantial misinformation. And I noticed the inquiry recommended that technical advice is routinely published, which is recommendation 4, but also specifically about the advice from chief medical officers and how it was made available to Parliament. So something perhaps to think further under recommendation 4. And then finally, communication. The report notes that the public health communications were not completely aligned with legislation and recommended an online portal so that it's clear what's advice, what's guidance, and what's actual law. And this very much chimes with some of our recommendations, that it's essential that it's established, but we need to just watch that it's accessible to the whole population so that inequalities are not enhanced. Because underpinning it, the aim must be to have greater public trust in the interventions that are being enacted. And the basis for that is obviously understanding what they are in the first place. I think that I've probably exceeded my time. So this is just some of the points I wanted to highlight from the report. And I'll hand over to colleagues to carry on the discussion. Thank you.
Thanks very much, Ruth. That was an extremely illuminating talk and gets us off to a terrific start. May I say to everyone who's joined us, there will be a quarter of an hour or maybe a bit more for questions and answers at the end of this webinar. So if you want to ask a question, please could you type your question into the Q&A box, and that will be monitored. Thank you very much. Thank you again, Ruth. Next, we have Professor Jeff King. Jeff is Professor of Law at University College London and Deputy Director of the Global Centre for Democratic Constitutionalism. Particularly valuable for our purposes was his membership of the Independent Commission and his position as co-principal investigator of the Lex Atlas COVID-19 project, in which 190 jurists across the world produced the Oxford Compendium of National Legal Responses to COVID-19. And there's also a forthcoming book comparing COVID laws, a critical global survey to be published by Oxford University Press. He was legal advisor to the House of Lords Select Committee on the Constitution from 2019 to 21, and from 22 to 24, he served on secondment as the Director of Research at the Bingham Centre. All of that makes Jeff extremely well placed to contribute to our webinar. Over to you.
Thank you very much, David, for that kind introduction. I was just thinking about this large project, the Lex Atlas COVID-19 project. It actually came about when I was doing legal advice on the coronavirus bill going through Parliament, and I realized that we were taking these enormously significant legislative decisions in splendid isolation from all the European neighbors who are also quickly doing something similar. And that's where the thought of a multinational project looking at what countries were doing would be useful. So I'm going to focus on the recommendations in Chapter 13 of the Hallett Inquiry's report that's under consideration today. And it has 3 recommendations. What I say will really fit, I think, very well with what Ruth was just saying. So some of the similar terrain will be covered, but hopefully not exactly the same thing. So recommendation 15 is the recommendation that the inquiry makes about what kind of scrutiny there should be for public health regulations. Recommendation 16 is about the call to review the applicability of the Civil Contingencies Act, as Ruth was just explaining. And 17, the third and final recommendation emerging in that part of the report, is about a repository for law and guidance so that citizens can understand what it is that they need to do and should do. So I don't have much by way of complaint or further illumination on the third proposal. I think it's a very good idea. But I do think that recommendations 15 and 16 differ in substance from what the Beatson Commission had decided, and had decided after very protracted debate, not divisive debate, but inquiry on the back of an incredibly large number of oral evidence sessions, not an incredibly large number, but a significant number, as well as written evidence, and then debate amongst the commissioners who had all taken an interest in this stuff. So, what were those differences, and why did we take a different approach on the commission? Well, recommendation 15 acknowledges that the best type of way to make in large policy decisions is to do it through primary legislation. And it accepts that that's not always possible. In fact, it's rarely possible in a pandemic. And it was rarely possible anywhere in the 53 countries that I'd looked at in the Lex Atlas COVID-19 project. It was all done by executive legislation. And I haven't seen any suggestion that it could be done differently. So, having regard to that, the Hallett Inquiry report seems to suggest that a draft affirmative procedure is the gold standard that should be used for most public health regulations, rather than the made affirmative procedure that we used. And what that means essentially, and for those who might not know the parliamentary procedure that well, under a draft affirmative procedure, the regulation is laid in draft before Parliament and does not come into force until it is approved by resolutions of both houses. Under the made affirmative procedure, the law will become effective when laid before Parliament, but can be negatived by a vote that must happen under the current law within 28 days, parliamentary sitting days, that is, of being laid. And what the Hallett inquiry is proposing here essentially is that the draft affirmative be used most of the time and a made affirmative be used not very often. And when it is used, that it be 21 days instead of 28 days. Now, in our report, we didn't suggest that draft affirmative should be the default position. And the question is obviously why, because it is, if it's available, if it's appropriate, it's clearly the better procedure to be used. That's a standard position. And the reason why we didn't suggest that it should be used is because of the very thing that Ruth commenced her presentation by indicating, which is that there will often in a pandemic be a need for very quick action. I think we can all remember it was the evening, I believe. It was either March 19th or 20th, where the Prime Minister came onto national television and said, "You must stay home." He really didn't want to do that. He was not, and the inquiry shows this, he was essentially dragged to that position. Now, he could have announced it with law, and in fact, he didn't have a legal backing for that. The question is, why would he announce on national television something like that he didn't want to announce, instead of using legal procedures which were available to him and which were used later that week? And the simple reason is that his health team probably explained to him that the consequences of waiting even another day could be absolutely spectacular in terms of the reproduction rate of the virus. And I mean, thousands and possibly even tens of thousands of people could die if you waited another few days, because the early advice in the lockdown was that the virus was doubling in size every 2 to 3 days. I don't know if in hindsight's validated that estimate, but those were the kinds of scenarios the government was working with. And so that need for speed is the default position through the pandemic. If it's school closures, it's a similar kind of thing. If it's even reopening questions, you'd think that should be done by draft affirmative procedure. But then there's an honest debate to be had about whether insisting everybody stay at home or in lockdown as the parliamentary wheels turn for 2 weeks is the right position. It's not entirely clear, even for a reopening decision, that is the case. Now, what's the difference, practically speaking? To use the draft affirmative procedure, the regulation must be written in draft, laid before Parliament, and ordinarily you'll have a number of select committees that will review the instrument and report on the instrument before it comes up for a parliamentary debate. So, if you use the draft affirmative procedure in this extremely sort of fraught schedule where it needs to come into force as soon as possible, they will build up a pressure to hold a vote on it before the select committees can report on it. and to hold that vote as quickly as possible. And in many cases, parliamentarians wouldn't have the benefit of the reports of the committees or advice from their own teams, and they would be rushed into a debate on a measure and told that the consequences of not approving it would be dire, and probably would be in many cases. So I think the thinking that happened in the commission that we had organized was that it wouldn't be wise to repeatedly force that type of situation. And so that's why we weren't pushing for draft affirmative to be the default position. The Hallett Inquiry report recognizes that it will not always be available, and so it hopes that in some cases the made affirmative procedure would be used instead. And I feel that it's good to recognize that it will be needed sometimes. The tenor of the report suggests that it should be available in very rare cases, whereas I think it's probably going to be needed more than half the time based on the kind of instruments that we were looking at. It was used much more than the draft affirmative procedure was used. And the inquiry suggests that there should be a written statement about why it's needed. I think that's a great idea, but it won't be much of a restraint on government. It won't be hard to produce those written statements. And that there should be sunset clauses for the regulations. That's a great idea. We had exactly the same proposal in our report, and happily, our recommendation for how long the regulations should stay in force are the same. It's 2 months. That was our suggestion as well. So I think that effectively is the key difference between recommendation 15 and what we're recommending. But it's not the only difference. I'll just mention a couple of other features of what we recommended in our commission's report. First of all, we suggested that there should be an initial declaration of an urgent health situation, and that there should be parliamentary debate on the existence of an urgent health situation or a public health emergency. We've adopted that type of language, urgent health situation, and that declaration should come up for renewal every 2 months, and there'd be a general debate about it. And part of our reason for suggesting that is that it would provide parliamentarians an occasion to discuss the ongoing need and not just the details of the regulation before it when it's approving regulations, but the grounds for the emergency, and to express views about what other things the government should be thinking about and doing. On the made affirmative procedure, after significant discussion, we recommended that impact assessments should form part of the procedure, an important part of the procedure, that there be a requirement to take into account any advice from the chief medical officer, which Ruth has just explained as well, and that there be a 14-day period for approval of made affirmative regulations, which is a week shorter than what the Hallett inquiry has recommended. And we also provide for what the position should be if it's necessary to recall Parliament, which is a very easy situation to envisage between parliamentary recesses and prorogation and so on. It's not a small bit of the parliamentary calendar. And on the draft affirmative procedure, we have a few things to suggest. So we suggest that the sunset clause should be 6 months for draft affirmative procedure, which could incentivize the government to actually use the draft affirmative procedure because they get something in return for doing that, for instance. And we specify the role of impact assessments there as well. The last thing that I think is quite important that we discussed that I have time to mention is that we advised that there be a ministerial duty to have regard to the guidance of national human rights institutions when preparing their regulations. And the reason for this is we think that consideration of human rights is extremely important and should be mainstreamed. We don't think that using a judicial review procedure is the best way to bring advice into the picture. It's better to have it upstream, and that this would be the best way to do that on the whole. Right. So on recommendation 15, I'd say those are the main points of difference. On recommendation 16, I can be briefer here because Ruth has done such a good job. I would say the one person that's really cited and quoted in that discussion on the need for clarity was Prime Minister Johnson, who I don't think has really validated himself as a master of detail or someone who really respects the need for the devolution arrangements in a particularly vigorous way. It seemed one of the suggestions in that part of the report was that the Civil Contingencies Act could have been used to provide a more joined up response. But that doesn't give a huge amount of weight in our Constitution to the important need to allow the devolved governments to be playing a key role in these decisions. I mean, lockdowns, shop closures, and so on, these are fundamentally issues that are very close to home. And the Civil Contingencies Act doesn't provide for that. It would centralize those decisions in Westminster hands. And I think that that's something that could be um, uh, difficult, to say the least. And I think the government actually did get that decision right. In terms of the actual benefits of using the Civil Contingencies Act, people think it's better because its parliamentary accountability procedures are very robust. It says that uh, any regulation must be approved by Parliament within 7 days of being made. I believe this is provision, and it lapses within 30 days. Well, that looks great. But if your legislation are complex public health regulations that are requiring shop closures and school closures and people to stay at home, then you may want to have more than 7 days in Parliament to have a look at the detail. And with the benefit of Secondary Legislative Scrutiny Committee reporting or the JCHR having a look. So those timelines could end up, and with a 30-day sunset period, it could create a sort of a spinning wheel of regulations flying into Parliament that need to be rubber stamped because of the number that they are, how quickly they need to be renewed, and so on. So that's the unsuitability of that procedure for something that needs as frequent consideration as what we're talking about. I think that's the one problem. The second problem is that it doesn't allow the devolved governments a role in the process. And the third is that you can do almost anything with those procedures under the Civil Contingency Act. Henry VIII powers are easily accessible under those procedures, and they're not under the public health legislation that was relied on during the pandemic. So that is one reason, I think, to not rely on the Civil Contingencies Act and rather to have bespoke public health legislation for public health emergencies. And that would involve, I think, under our current legal framework, probably amending the Public Health Control of Diseases Act from 1984 with the kinds of policies that are discussed in the report here and the ones discussed in our commission report. Rather than relying on the Civil Contingencies Act. It may be that we have another act like the Pandemic Act or something, but we need a general framework for infectious diseases that's not limited, I think, to particular diseases like flu. But a Pandemic Act could be another approach. Okay, so I think I'll stop there, David, and thank you very much.
Thank you very much. That was terrific, Jeff, and brings us on now to Dr. Rebecca McKee, who is a senior researcher at the Institute for Government, works in the Ministers team with a focus on Parliament and public inquiries. She also works on the Public Finances team with a focus on regional economic growth. Her background is in politics with a PhD in politics. And previous to working at the IFG, Rebecca worked at the Constitution Unit at UCL as a British Academy postdoctoral research fellow, where she led a research project on MPs' staffing arrangements. Rebecca's also worked for the participation charity Involve, project managing deliberative processes, including the Citizens' Assembly on Health and Social Care and Climate Assembly UK. And Rebecca was one of the researchers on the Institute for Government and Bennett Institute review of the UK's constitution. So, Rebecca, over to you.
Thank you, David. for that introduction. I promise that at least some of that quite scattered previous history is relevant to the webinar today, namely the work I'm doing at the Institute for Government at the moment, which is some of the work we do on public inquiries and also some of the work that we do with ministers. Also hope to feed in some of my other colleagues' reflections as well, as we ran our own webinar last week as well. So hopefully I can accurately reflect what they've said. I think in terms of some of the key takeaways from the inquiry's report, I wasn't involved in the commission, so takeaways I think are a little bit different, but I think hopefully complementary. The first thing is that the inquiry has an awful lot to do. It's a very weighty and detailed report. Those of us who have read it, the conclusions, they're lengthy, and I think the inquiry has been fairly effective in establishing a public record of events, especially in the kind of early part of the pandemic. And it's worth noting here that the statutory powers that the inquiry has helped. Like the inquiry has been able to compel the government to disclose material, including some that it resisted releasing, including WhatsApp's private notes. And there was a judicial review in the summer of 2023. But where I think it's been less successful is in kind of providing the level of detail in the recommendations that is needed for government to kind of really grasp these and take these forward, and that it kind of don't allow the current government or future governments to think that these aren't relevant for us. These are really about people and personalities that were kind of there at the time and how this relates to the kind of political decision-making side of things. And in part, this is because the inquiry has a really broad terms of reference set by the then Prime Minister Boris Johnson, who took on board recommendations from the chair, Baroness Hallett, and was actually informed by a consultation with people including bereaved families. But the inquiry is bound by those terms of reference, which give it really rather daunting task of examining the UK's preparedness and response, of producing a factual narrative account. And if you read the terms of reference, there's a huge number of subsections under this, but also learning lessons for the future. And just to put it in context, this is only module 2. It's likely to be the biggest module, but there are 10 modules, which I think we're expecting to be published sort of next year. And just to say as well, one of the other takeaways is there is huge value in running this inquiry process, recording the government's pandemic response, for not only those who've been directly impacted and who felt sidelined, but also those of us working in and around government, to be able to kind of point to it and say, look, these are some of the real life consequences of the things that we try and talk to you about decision making and having things in place and working with your team. For example, although a lot of media focus has been on the kind of March 2020 early stuff and the figures around deaths that would have been avoided with lockdown, Baroness Hallett also said it was inexcusable that the government hadn't learned lessons already by later in 2020. And I think a key takeaway is really that it took the system far, far longer than it should have done to gear up for that second phase of the pandemic. That is something that is very important for ministers, this government and future governments to remember, and having that on record is really helpful. It also helps to galvanise attention, which I think you can see from the wide range of responses from people across the UK and devolved governments to this report. Even if we feel like some of the lessons have been presented elsewhere, having it in report statutory inquiry has actually been very helpful for kind of galvanising and drawing people's attention to it, that like 5 or so years on from the initial stage of the pandemic. But the key reflection really is that we don't feel like we have learned a huge number of new things in this report for how the government should improve the way it prepares and responds to a crisis, thinking about some of the internal decision-making structures. There's definitely some specific new things that it has surfaced, but as others have already said, some of the recommendations that have been made by others, including in the commission, have already gone a bit further and provided a bit more detail about the kind of like how you implement these things. And actually, I think this reflects really the issue with the model of public inquiries rather than necessarily this inquiry itself, but I'll come back to that at the end. So just to pick up on some of the things from IFG perspective that we think are quite interesting. So it's really brought to the fore kind of the issues with culture. These are well known, but it's really important, as I said, to have this on record. And these are things that exist sort of in normal times, but especially in a crisis, they're particularly acute. So things around the importance of having good ministerial leadership that really sets the entire tone for the department. And in a crisis, high stakes, high pressure, you need a leader who can recognise this and support their team to look after themselves and each other. And it's clear that that was really lacking. The other thing is really that the pandemic needed a whole of government approach. Now, the inquiry is critical of the mistake for DHSE to be put in the lead in the early stages, and that it needed the centre to take a hold of things. And the consequence of Boris Johnson not chairing the early response meetings, which and sometimes could have been completely fine, but this really sent a signal to the entire system that this was a health response. So the sun, I think, is now blocking me out. I'll put my it's sunny in northeast London. But yeah, I think the fact that this sent a signal that this was kind of like a health response first rather than a whole of government response. And this reflects, I think, some of the failures to deal with the economic and the non-pharmaceutical interventions as like linked things and really work through those trade-offs. And that's something that's highlighted in the report, which I think is very useful. It also helpfully sets out some of the key things that ministers should be thinking about in a crisis and things that they need to do. So I think about setting out clear objectives. The report clearly sets out that they were not clear enough throughout the pandemic. The objectives were shifting and changing, and there wasn't much clarity over why. And having chosen objectives, the decisions, making process wasn't there to follow through on decisions in a timely manner. And also, I think what's really interesting is that not making a decision. So the uncertainty at the start meant the ministers didn't take decisions, and actually this report helps to highlight that not taking a decision is still a decision, which again is something that's really useful to point back to. The inquiry also talks about communication, both within ministerial teams and with the public, and it covers some of the bigger structural things as well. So, for example, that COBRA wasn't the right model to run long term throughout the pandemic. But as I've already said, that with this and in other areas, I think the report misses out on some of the detail of what should be done differently now. And really, this is an opportunity now and a job for the ministers, civil service, to work out how they take this forward and think, okay, how are we going to change things? What do we do now? How do we make sure that in the next crisis, we can get the information in and decisions out in a way that's more strategic and structured than in the pandemic, and work through what it kind of means for them in their jobs now. I just wanted to touch quickly on the kind of governance and decision making across the UK. I know Rita has touched on this a bit, but from a slightly different angle. I think it's really interesting the comparative approach that the inquiry took in this module to have all four governments, UK and devolved governments, considered together. It's a novel choice, and I think it has actually been quite successful in revealing the differences in each government's approaches, potentially highlighting some of the lessons they might be able to learn from each other. The sort of second half of that intergovernmental work is looking at how the UK and the devolved governments interacted. And here it really highlights, again, something we already knew but is really helpful, is the role of personal relationships and the discretionary decision-making by UK ministers and the Prime Minister, highlighting this lack of regular system of intergovernmental relations, which was fairly experimental and adapted as the pandemic progressed. And there's been some work in the interim on IGR since then, as well. But yeah, one of the main things is the main, I guess, takeaways for us is that across all of the themes, I think the diagnosis is really largely correct and in line with a lot of things that others have said, either at the time or since, that better long-term thinking would really help the government ensure it doesn't repeat mistakes between phases of a crisis. It would help ensure that ministers, the UK government, can collaborate more effectively with their counterparts in the devolved nations, and also, as we point out, with the local devolved administrations in England. But there's this lack of detail on the actual proposed solutions, which just risk it being easy for this and future governments to kind of ignore the lessons simply because they weren't involved, even though many of the challenges are still very, very relevant. Which brings me back to some of my thinking on kind of public inquiries as a model for kind of doing this kind of work. And as I said, the inquiry is established with broad terms of reference, a huge amount of things to kind of look at. But in terms of how it creates recommendations, it is limited in this model of reflecting the kind of evidence that the inquiry receives. And it's difficult when you're looking at systems like government, how decision making is made, which can be formal, informal, and lots of things going on, to kind of know what you don't know. And I think this is reflected particularly in this report. And also the process where you're putting witnesses, essentially like cross-examining witnesses, putting them on defensive, is really suitable for establishing facts and suitable for some witnesses, but it's less effective for probing deeper into decision making with potentially a wider set of civil servants, and potentially those who are more junior as well, who could really illuminate some of the stuff, either what had been happening or kind of how you might implement those recommendations going forward. And there's limitations, therefore, too, in the way that inquiries often develop recommendations. So there could have been more to kind of gain from testing those a bit more with people working in the system, but recognizing that this inquiry in particular has an awful lot that it needs to get through. So really, just to finish on that, I think this really helps to highlight that, yes, there are some things that like the inquiry could do differently, but I really think this is a lesson for government in picking the right model, the right tool for the job. And there's a case for running a sort of more targeted, more timely review, potentially between different phases of the pandemic or sooner, that could still run alongside an inquiry that does some of the kind of much bigger fact-finding and accountability work that I think is so important. The final thing I just wanted to end on really is that there's an implementation challenge with all of this, despite recommendations from various sources that have preceded this inquiry, but also from Module 1, implementation has been slow. And, in part, I think this is for the government and the civil service. We've been told people were waiting for the inquiry's findings before they implemented some of this, but obviously it's also a convenient reason to delay action as well. And I was reminded by someone the other day about the Phillips inquiry into BSE, which was published in 2000. And I went back and looked at the sort of blurb of what the key findings of the inquiry were, which was a failure of the government and regulatory bodies to recognise and act upon the emerging threat. Highlighted that initial warnings from scientists were not adequately heeded. There was a lack of effective communication, coordination, and also that economic interests were often prioritised over public health concerns, which led to delays. And I think if you read that, it reads very much like some of the findings from the COVID inquiry. So it really highlights that there's an issue, a wider issue, in the way that government takes on and implements recommendations from reviews, inquiries, various types of investigation, which I think just this report itself has highlighted for me.
Thank you very much, Rebecca. That was fascinating. And I thought that the parallel you drew there between this inquiry and the 2000 one was extremely interesting. Thank you. We now have Dr. Colin Cachy, who's Director of Policy at the Northern Ireland Human Rights Commission, and in that role responsible for the provision of advice to the Westminster Government and Parliament and to the Northern Ireland Executive and Assembly on the human rights compliance of legislation. Colin also oversees the Commission's monitoring reports to the UN and Council of Europe human rights systems. Colin led the Northern Ireland Human Rights Commission's work responding to the COVID-19 pandemic and the Northern Ireland government's plan to introduce a new public health bill for Northern Ireland. So, Colin, you're right in the heart of this. Over to you.
Thanks very much, and thanks for the opportunity to speak today. In my presentation, I'm going to provide a brief overview of proposals for reform of public health law in Northern Ireland, which have been brought forward since the coronavirus pandemic. And in doing so, I will draw some observations on the COVID-19 inquiry second report and on the Bingham Commission's report, which informed those proposals. And the theme that will run through my observations is the importance of public trust in both preparing for another pandemic and in the decision-making that will occur when another pandemic unfortunately appears. As has been said, my day job is to advise and assist officials or elected representatives on making revisions to public policy proposals to ensure human rights compliance. And in light of my experience, I want to reflect on how we bring about the reforms being recommended by the COVID inquiry, so that we don't see a repetition of, as Rebecca said, where we've had previous reports that haven't actually led to law reform. I will be discussing the proposed public health bill, which is being developed by the Department of Health. The Commission has been asked to advise on the policy underpinning the bill, and envisages that we will assist in the development of the human rights impact assessment to support the Department of Health officials who are responsible for the bill, and a number of those I know are watching online. In Northern Ireland, public health powers are governed by the Public Health Act, Northern Ireland 1967. This allows the Department of Health to make regulations to prevent the spread of infectious diseases. And as acknowledged in the COVID-19 inquiry second report, this legislation lacks some of the more detailed provisions found in the frameworks of the other nations. In common with the other nations, Northern Ireland relied heavily on secondary legislation with limited legislative scrutiny during the coronavirus pandemic. And anyone who's read the second inquiry report will note that the Northern Ireland Executive is particularly held out for criticism for their approach to decision-making during the pandemic. The 1967 Act was reviewed in 2016 and was found to be deficient in a number of aspects, including a failure to be informed by human rights and failing to require authorities to act in ways that are proportionate to threats to public health. Unfortunately, work to implement the review was paused in January 2018, a decision which was made without any controversy or criticism, which I think highlights the lack of priority afforded to public health legislation outside of a pandemic or in the immediate aftermath of a pandemic. I don't think that is peculiar to the Northern Ireland Assembly. Legislatures will always have plenty of legislation to scrutinise and consider and to prioritise, but the tendency for legislatures to put public health legislation into the too difficult pile is something that we need to be cautious of in considering required reforms in light of the COVID inquiry report. And I must draw the contrast. My commission would be much more experienced in advising on counter-terrorism and national security pieces of legislation, and the speed with which those provisions are implemented and passed through Parliament when they're considered necessary to protect the public is night and day in comparison to protections for public health matters. So following the COVID pandemic in May 2022, the Northern Ireland Minister for Health established a bill team tasked with bringing forward a new public health legislative framework to ensure the prevention and mitigation of the impacts of infectious diseases, environmental, chemical, and radiological threats to individuals. In July 2024, the Department of Health published their proposals for a new public health bill, and the bill would provide public health powers, including powers of entry, investigation, quarantine, and isolation, the sort of full suite that we discussed earlier. The proposals were the subject of significant online debate. Misinformation regarding the content of the proposals and their stage of development generated significant opposition to the proposals. And MLAs from across the political spectrum in Northern Ireland were approached by constituents with concerns that the proposal would empower the Department of Health to impose considerable restrictions on their personal freedoms and on access to services, including access to school for children. These concerns were often phrased in human rights terms, but there was rarely a detailed consideration for the balance required in terms of the state's obligations to protect the rights of others. And a lot of it was taking place online rather than sort of in informal meetings or even in TV discussions. So Twitter and X, as I understand it's called, were the main forums where this was being discussed. Most significantly, concerns were raised regarding the potential for the bill to impose a mandatory vaccine requirement on members of the public, and individual MLAs were critical of the consultation document. However, Colin McGrath, an MLA, in commenting on approaches that he had received from constituents regarding the bill, said that the frustrating thing was that much of what was being said was not borne out if you actually read the consultation document. The Human Rights Commission operates an advice clinic for members of the public, and many came to us raising concerns about the consultation document. But we had a similar situation that people were concerned more about what they read online about the proposal rather than what was actually set out in the proposals themselves. And there appeared to be a lack of appreciation for the key goals of the proposals and a lack of appreciation that the 1967 Act existed on the statute book, providing public health enforcement powers, but without the protections proposed. The department released a number of press releases and documents attempting to address concerns, and the Minister of Health specifically stated it was not his intention to bring forward proposals relating to mandatory vaccinations. Department of Health officials informed the Committee for Health, and I quote, that misinformation led to people thinking that we were trying to do things that were draconian when in fact we were actually trying to go in the other direction. And I'd concur with this assessment. Earlier in November, the Minister of Health confirmed that over 8,000 responses to the public consultation were received, and that he had directed his officials to re-engage with stakeholders, and acknowledged that concerns about human rights and the potential overreach into people's personal freedoms and decision-making were a significant concern. So whilst the policy document relating to the bill could have included greater analysis of human rights, of the human rights implications of the proposals, this is clearly an example of a policy proposal with significant potential to enhance human rights protections being disrupted largely due to online information. And anyone who's read Chapter 11 of the second COVID inquiry report on government decision-making will note that Northern Ireland ministers and elected representatives come under significant criticism for failing to show leadership and for failing to see beyond political division during the pandemic. In particular, the use of the cross-community voting procedures over COVID restrictions is highlighted as being an inappropriate approach. And unfortunately, I think during the debate on the public health bill, we continued to see political disagreement hampering meaningful debate. In response to the Minister of Health's recent announcement on the bill, one MLA commented that the draft proposals represented a massive overreach and risked handing sweeping powers to the Department of Health without proper democratic oversight. This said that the experience of the COVID-19 pandemic must never be repeated in a way that tramples on personal liberty or undermines public trust. So the language is not very much focused on what is actually being proposed or the detailed and considered decisions that need to be made in a crisis context. So respectfully, I'd suggest that statements such as this have contributed to a lack of appreciation for the fact that the 1967 Act remains in law, providing the department with significant powers, but without building in important human rights protections. During the pandemic, over 100 statutory rules were enacted by the Northern Ireland Executive Departments. Of those, 83 were made without prior approval by the Assembly on the basis of urgency. And the lack of scrutiny is specifically highlighted in the second COVID inquiry report. The Department of Health proposed the Public Health Bill to provide the Assembly with greater control over public health protection regulations. Indeed, these proposals are modelled on the report of the Bingham Commission, and in line with recommendations 3, 4, 5, and 6 of the Bingham Commission's report, the Department of Health suggested that public health protection regulations should be enacted by way of an affirmative scrutiny procedure. And access to this procedure would be contingent on the Minister of Health making a declaration of an urgent health situation in consultation with the Chief Medical Officer with respective sunset clauses and confirmatory votes. In line with the Bingham Commission and indeed the COVID inquiry second report, the Department of Health clearly considered that providing greater accountability to the Northern Ireland Assembly will ensure greater public trust and confidence in the laws enacted during times of crisis. And these provisions are much needed and will hopefully go some way to meeting this goal. However, that of course is contingent on members of the public themselves having faith in their elected representatives, to be mindful of their rights and of the need to balance competing interests to ensure laws are in the public interest. And we hope that upon reviewing the second COVID inquiry report and its account of political disagreement regarding restrictions, the decision makers will come together to determine a better framework for decision making in the future. As the Commission re-engages with the Department of Health, we will consider how we as a national human rights institution can raise awareness of the problems with the 1967 Act and the need for reform to ensure respect for human rights in the event of another pandemic. In addition, we will consider how we can better inform the public on the inevitable human rights implications of public health measures and on how proportionality assessments can and should be carried out by decision makers. Whether a reform procedure which provides the Northern Ireland Assembly with greater control over the enactment of public health regulations will generate greater public trust is contingent on the public having trust in the Northern Ireland Assembly as a democratic institution. And evidence from the OECD consistently demonstrates a lack of trust in public institutions and legislatures. And public distrust in democratic institutions leads to members of the public turning to social media and other sources which are rife with disinformation. So this broader challenge is something which we all need to be mindful of as we seek to ensure that public health laws empower decision makers to intervene in a proportionate human rights compliant manner. And the Commission looks forward to advising the Department of Health officials on next steps to modernise public health laws in Northern Ireland. And we're exceedingly grateful to the Bingham Commission for the time and expertise invested in producing the report on UK public health emergency powers, which I hope will inform the next steps in Northern Ireland. So thanks very much for your time today, and I really look forward to the discussion.
Thank you very much indeed, Colin. That's a fascinating account of the difficulties in getting a rational debate about new public health measures going. in divided parliaments and executives, and I think that's very telling. If I can just, at this point, sum up perhaps some of the themes that people might want to take up in the question and answer session. They seem to include the problem which Ruth pointed to about the developing nature of emergencies and how one can decide when there is an emergency, if one is going to have special emergency legislation. And something that the independent commission looked at was whether there should be at some point a declaration of public emergency, following which everyone would know that they were dealing with a situation which might justify the imposition of exceptional powers and the use of exceptional legislative procedures. The question of which model of powers we want, and whether the, as Jeff pointed out, whether the use of the draft affirmative procedure for regulations was the best way to go in an emergency, and whether it was even feasible to do that. The question about whether we should worry about the Civil Contingencies Act at all in these situations, or should try to find a way which doesn't depend on that, but has a perhaps more focused and realistic approach to legislative requirements. Rebecca's point, which I found extremely interesting, not just about the different types of issue that an inquiry of this sort is trying to deal with, but the possibility that perhaps we need different inquiries or mini inquiries for different types of concern about the way in which things happened and how we can learn lessons from them. And I was also glad to hear that the sun was shining in North London, because it's extremely wet here in Leeds. And the way in which, within a rather divided government, a failure to take decisions is also likely to be a decision in itself, which means that one has to think much more carefully about how we allocate decision-making power and how we coordinate across government departments, which is something which doesn't seem to have been terribly effectively achieved. And the important question that Colin has raised about the way in which one garners support for reform in the post-pandemic moment, when we are thinking about how we're going to shape our response to the next emergency, whatever it may be. And the difficulty of maintaining the public's trust in the democratic processes of government and legislature are not limited to Northern Ireland. I think one of the things that the inquiry report does usefully is to draw a link between misbehaviour by leaders and trust in their response to the emergency, which may undermine respect for whatever decisions are taken now, as we try to find a way to prepare for the next major health emergency. Those are just a few of the points that I found very helpful, and may focus questions. So if I can move to the Q&A, we have two questions here from Tony Yates, who says, as a member of the Older People's Network Disability Politics UK, it started work on a GCSE medicine syllabus, and he wonders whether an educational training program, such as more education at school on medicine and public health, have helped to mitigate the impact of the pandemic. Is there a sense of whether the process of dealing with the pandemic would have been made easier by having had a school level training or education in the risks and possibilities? Would anyone like to make a start on that?
Perhaps if I could just make an observation. I think the question of health literacy generally is really important to consider, and whether we pay sufficient regard to people, young people being educated in, health and how the human body works and so on. So I don't know what's intended in a GCSE medicine syllabus, but I think anything that helps people to understand the influences on their health and well-being, what they can do about it, and a general understanding is good. We know, for instance, programs have been run for people who've developed chronic illnesses to help improve their understanding of those particular illnesses. Whether or not, I don't think I can answer the question, would that sort of course have helped mitigate the impact of the pandemic? It may have. That type of work can help people understand why decisions are being made, understand how viruses spread, understand why social restrictions are introduced. So I do think it's important that due regard is paid to supporting people to be able to counteract misinformation that they hear from others. I think that understanding what evidence-based decision making involves, knowing how to trust that evidence is also really important. I'll stop there. Thank you.
And that actually ties in with an initiative that I think is on the government's agenda to get schools to train their students in how to recognise fake news and how to respond sensibly to the misleading nature of a lot of stuff on internet sources. Would anyone else like to come in on that? In that case, a further question. As we move forward, are there ways in which the inquiry structure could be improved, do you think, to enhance the ability of inquiries to make recommendations for the future, rather than focusing on the mistakes of the past? And this is something which Rebecca raised, so perhaps over to you.
I am happy to take that. I think one thing to note as one of first principles is that statutory inquiries underpinned by the inquiries legislation actually have a lot of flexibility for kind of how they approach things. The terms of reference and kind of the early decision making made by ministers who set them up are really key. So it's not that there's like one kind of model for every inquiry and it's seeming to kind of fix all inquiries in that way. But there's definitely lesson learning that could be done between inquiries much more effectively on kind of how different chairs and inquiry teams approach some of the recommendation testing. And I know, for example, in inquiries and reviews and other types of investigation that deal with kind of like health systems, much more targeted, there's often a lot more work that goes on to kind of like the systems testing part of the recommendations that can kind of help to illuminate some of the issues of like, if you pull on this lever, you'll unravel this bit, or like, have you actually got to the heart of like where the problem is? So there's probably a bit more learning that can go on there. I think this particular inquiry, there's just so much that it kind of needs to cover, and there's a wide breadth of it. The other thing is that just to note, the Parliament is currently considering what was called the Hillsborough Law, which is giving part of what it's doing is in creating a duty of candour and a duty to assist, will give non-statutory inquiries more teeth. It comes on the stuff I was talking about in my presentation up top around the importance of this inquiry being able to compel witnesses and compel evidence. And actually there is again a lot more flexibility in how you would run a non-statutory inquiry, for example, that a minister has also established. Not just in kind of the recommendation phase, but also in the way that you take evidence. So running kind of more potentially like private sessions with people who you really want to like get at kind of the more granular detail of how things happen, but you maybe don't feel the need to have that as the public record if they weren't necessarily the people that need to be held accountable. There's some other ways that you might be able to do that with the models. Where I think we haven't got to currently is setting out what the different types of models of public inquiry do, and then that leans into this kind of public trust question of why government often calls for like the big hefty judge-led statutory inquiries, and there's definitely a job in communicating what all these different models are doing, what they can achieve, and you know that they do have that once Hillsborough Law is in, there will be more teeth for them to be able to kind of get to the truth. So I think in part there's more flexibility than we think. There are other models, but there is a job to do to kind of set that out, I think, for the public and for ministers so that you're picking the right tool for the job.
Thank you. So are you suggesting that we need a more nuanced range of types of inquiry rather than going from a usefully flexible non-statutory inquiry at one end across to the full public inquiry statutory powers to compel evidence and so on at the other end, that there's a case for having a range of different types of inquiry with different kinds of power and process?
Yeah, I think so. I think one of the issues of that is, although we have the flexibility, there's a lot of political pressure, public pressure to always reach for the thing that seems like the most robust, even though it's not necessarily the right tool. And that is really in the context of low public trust generally, but specifically low trust in the government when you're dealing with issues where government or other agencies have not been forthcoming, have not been admitted their role, not been held accountable. And so it feels like kind of reaching for that gold standard is often a thing that happens, for example, even if it's not the right kind of tool. And I think the other part of that is that inquiries being ad hoc, they aren't necessarily doing an effective job of learning from each other about different ways of working, different ways of design. And one way to kind of mitigate that is to have a set of different models that there's kind of research on design that sits underneath them that you can then take to ministers and say, this model will be best for this topic because what we're really trying to do is a rapid review of lesson learning, or this one is where we're really keen to find out exactly what happened in a very forensic way. But I think you need a better framework to kind of get past some of the issues that have seen us always reaching for the kind of what's seen as the most robust model, even if it's not really the right model for the topic.
Thank you very much. The question moving from the inquiry sort of the way of shaping the implementation. The CEO of Disability Rights UK notes that they have been core participants of the inquiry, and he gave evidence for Module 2. And the question is what their advice is on how best to take the report recommendations and influence government to take them seriously and implement them, which of course assumes that one agrees with the recommendations. Would anyone like to have a go at advising on that?
Yeah, I'd be happy to give an initial response. Thanks very much for the question, Cameron, and thanks for all the work that DR UK do. What I think needs to happen is that at Parliament, they need to establish a committee that would have responsibility for reviewing oversight of the recommendations, or at least the recommendations that are accepted by the government. I think you could also have in the devolved administrations a sort of parallel committees that could feed into the work of the committee at Parliament. There are also lots of different structures in place. There's the British Irish Council, there's an East-West Forum, where the devolved administrations and UK government come together to discuss issues of concern. Quite often they're quite light touch issues, sort of tourism and things of that nature, but the response to coronavirus should be or the next pandemic should be on the agenda of all of those meetings. So I think there's a need for structures in Parliament that would be there to monitor government's implementation of the recommendations, and then there would be a focal point for organisations to engage with, and then looking at those structures that we have in place to bring about collaboration between the governments in the devolved administrations and in Westminster would be a good first step.
Yes, Jeff.
Oh, I think Rebecca was going to say something too, and I'd love to hear what she has to say before I say anything more.
I can jump in quickly again. Just I think there's two parts to that question, which is probably what can people do now for this inquiry, which is that there is a major issue around implementation and follow-up, and I think it's now a job for government, but also organisations that have been involved in the inquiry to keep up momentum. The kind of modular approach to this inquiry means that this is like the final report of Module 2. So that is out. They will get a government response to that, and the aim is to have that within 6 months. So that will exist before the inquiry is finished. The problem is when the inquiry finishes, the inquiry is done. And so it's important for other organisations that care about the things in this report to keep that going. On the second thing, which is what you can do in the future, I don't disagree with Colin's point around parliamentary committees. I think current context where we have 22, I think, statutory inquiries currently ongoing across the UK, and a whole lot of inquiries that have recently concluded where the recommendations are still lingering, leaves a kind of difficult question there for the capacity of parliaments to take this on. And I know the House of Lords report recommended parliamentary committees as well. I think there needs to be more of an approach, which is finding the right model for the inquiry again. So, for example, I think it's the RHI inquiry in Northern Ireland that Northern Irish NAO is taking on some of the responsibility for monitoring and implementing some of those recommendations. So could be a role for an organisation such as the NAO in some cases. In Australia, they've used implementation monitors for a couple of inquiries, which are people who are deep in the policy knowledge, who kind of, know how these organisations work, know where the bodies are hidden, and can keep up that momentum. And so potentially in our context, where we have an awful lot of inquiries ongoing, there's more of an ask for kind of a range of options and to look at what might be most appropriate. But I agree, in an ideal world, Parliament having that focus point where people engage with, and the kind of expertise in Parliament would be excellent.
Thank you. Jeff, you wanted to?
I'm glad I deferred there because I have less to say substantively. My first response to Cameron is for civil society to maintain pressure, because there is a certain fatigue with this issue. I mean, I've worked on it for 5 years, and I can tell you the pressure to publish something earlier was extremely strong, and the sort of sigh that you get from people when try to put something out now, that again is very strong. And that those kinds of pressures have an acute impact on what gets prioritized politically. So I think you're right in thinking this is incredibly important. It will become the most important national issue before too long, because this wasn't even the big one, according to the public health experts. So maintaining pressure was the first thing. And the second, I think Colin's suggestion was excellent, and it sounds Rebecca thinks so as well, to have a parliamentary committee in place, because many of the proposals are not sort of self-executing. You can't just take them off the shelf and implement them. They need further investigation, and they might decide not to run with them. And the most transparent procedure for discussing that is the best one, I think.
Thanks very much. Next question is about how one should approach the role of local government in the regulation-making process. Granted that we have a very fractured political landscape across England, in particular, and can expect some local authorities to choose policies that will have health impacts on other local authorities. So it's seriously complex. And we saw this in the pandemic, when bits of large cities, or the whole of large cities, were suddenly being locked down when their neighbours weren't, without apparently very much prior consultation with people like elected mayors. I don't know, Jeff, would you like to take something?
I mean, you've put the issue in the air that I think is, and Ruth had mentioned the role of local government. I mean, when you're talking about local lockdowns in Manchester and you have a very responsible government in place, you can see the case for giving a role to the local government. If the local government is a little more they don't take the public health threat seriously, then you have a very different situation, because they could allow it to run riot there. And then what's the national government to do? Say you can't take a train from Manchester to London any longer. Those kinds of decisions are very difficult. And so I think one possibility is that local authorities can ratchet upwards but not downwards from a national baseline. If they think that the government in Westminster is not taking it seriously enough and they want to take further health measures, I think that's something that could probably be designed legislatively. But just giving local authorities veto powers over these things, I think could raise could raise dangerous situations, and or a demand for complex national policies that'll be very unpopular. The other thing is that we haven't had to contemplate the scenario where the Westminster government makes a decision that a devolved government is not acting responsibly. I think because they all were, but it is conceivable in the future that wouldn't be the case. And in Germany, they had to contemplate this and pass what they called the Federal Emergency Handbrake provision, to deal with the possibility of some of the Bundesländer not making the right decision. So I wanted to hear what other panelists had to think about this. I just was raising the issue. It's something the inquiry doesn't touch on.
Would anyone like to on that?
I can offer a very brief thought, which is it's such an interesting question, particularly, Jeff, as you said, around what you would do if someone took a lesser approach and how that affects local government. In England in particular, can fall down to some very small areas as well. Local authorities are not particularly big and do have powers. I think the thing I just was going to mention is that we're in the middle of the moment of what is termed, I think, still completing the map of English devolution. And so really just flagging that any kind of answer in this space would need to reflect that some places have got some very robust, far more established structures, such as Greater Manchester and the West Midlands, and other places are working on very new geographies, very new structures, for example, in the East Midlands, with a new mayoral strategic authority, and then some places are even further behind. And so you risk that kind of without being able to kind of share good practice and decision making across all of those, that some places are just simply left behind by a lack of good structures and kind of good leadership.
Thank you, Ruth. Do you want to add?
Well, just to echo, the reason I raised it was, it is a changing landscape in England, and it's vital that we have some scenario testing to understand who's got powers to do what are the circumstances that could exercise those powers, and what restraints are there on those powers. So it's really important. I think the English devolution has progressed since we considered the issues in our commission. So I think it is an area that really does need active exploration, not just thinking about the devolved administrations, but also regional powers that are now emerging. So yeah, it's a piece of work that needs doing.
Thank you. One, I think it's going to have to be the final question, as we only have a couple of minutes left. Should more weight be given to human rights protection in balancing between public health emergency measures and the well-being of individual citizens? That sounds to me like a really important but unanswerable question. But would anyone like to comment on Colin?
Yes, and definitely, I would agree with the suggestion on human rights protections being much more brought to the fore. I think looking at some of the commentary that we've had about the public health bill, it really brings to mind for me that a little knowledge of human rights can be a dangerous thing. Knowing what your human rights are is important, but you also need to know that your human rights are in many ways qualified, and that the way that you exercise your human rights can have impacts on others, and the state's entitled to place restrictions on those. So I think looking not just at sort of the grandiose language of human rights, but looking into the granular detail of what your human rights are and what your sphere of discretion is in your daily life, and how that can be restricted to protect others is something that we should be doing. And I think that links in with the earlier questions about educating people in terms of where they're getting their information from, and how they're assessing government proposals whenever they are brought forward. But I can respond very affirmatively that we should have more weight given to human rights protections in that balance.
Jeff.
Thank you. I think that I agree with what Colin said, and as I had mentioned in the report, we thought that there should be a binding obligation to have regard. That's a very specifically purposely chosen legal phrase, as in it would be judicially reviewable if the minister didn't have regard to the advice of national human rights institutions. I wanted to underline something that Colin had said. The human rights discourse sometimes serves as a kind of a libertarian critique of public health policies. Public health policies which actually have a very profoundly recognizable justification in human rights, the right to health, the right to education, the right to life. I actually think for most governments, the rights to life, health, and education, and to freedom of assembly and all of the other civil liberties were profoundly right at the forefront of what they're thinking, and that they really didn't want to do any more than they thought that they had to do in order to balance those rights out. I think they were honestly in taking that task, whether they got it right or wrong, it was in the forefront of their minds. The rights of vulnerable groups, I think, is something that is often not given enough attention. And it is a part of the benefit of those who do human rights work in their day, their regular work. And that's for instance, when Cameron Malik was talking about the work of Disability Rights UK, that's something that isn't always at the forefront of the government's the rights of people with autism, for instance, during the pandemic. There was litigation over that, and it brings to the fore things that otherwise aren't. And I think that giving greater weight to human rights could really be finding ways for representatives of those vulnerable groups to make sure that they are heard properly, and that public health decision making is responsive to it.
Thanks very much. That's the point, I think, and a very good point at which to bring our webinar to a conclusion. Can I express my thanks to all our speakers, to Ruth, Jeff, Rebecca, and Colin, for their very, very illuminating contributions, both to in their initial presentations, but also in the discussion of questions. Thanks also to the team from the Bingham Centre for making this all possible. And I hope that everyone will have found it helpful and perhaps even encouraging further thought. So thank you very much for that, and good afternoon.